Back in 2020, Louis Pino invested in Cardone Capital's real estate investment fund. He later became a lead plaintiff in a class action that claimed Grant Cardone made false statements. However, this initial proceeding was dismissed, and the appeals court has recently brought the case back to life. This case could be huge, with records showing that approximately 3,500 investors have invested almost $80 million. And guess what? The class action is open to all those investors. In this video, I'm going to share the allegations against Cardone and his companies, why the appeals court overturned the original decision, the huge tragedy that occurred during the proceedings, and the next steps in the case. Yeah, that's right, it's not over yet. And unlike some videos have said, Grant Cardone and Cardone Capital have not been found liable for any damages, nor have they been found guilty of any crimes whatsoever in relation to this case, at least not yet. So let's get to the facts. The story starts with Mr. Pino scrolling through social media and apparently seeing some of Grant Cardone's posts and videos. According to court documents, Cardone was boasting on Instagram that investors could double their money. The plaintiffs also allege that Cardone said this in a YouTube video: "You're going to walk away with 15% annualized returns. If I'm in that deal for 10 years, you're going to earn 150%. You can tell the SEC that's what I said it would be. Some people call me Nostradamus. Because I'm predicting the future, dude, that's what's going to happen." Pino, an unaccredited investor, eventually invested $10,000 into Cardone's real estate investment fund. Interestingly, around this time, the SEC filed a review letter publicly on its online documents register, EDGAR. The letter informed Cardone that 15% internal rate of return and distribution figures lacked support and must be removed from the official offering documents. And according to court documents, Cardone quietly removed those statements from his offering materials. However, he didn't explain this to the public or to investors. Now we're going to talk about that letter shortly. As I mentioned earlier, Louis Pino filed the class action lawsuit with the other plaintiffs. That was in September 2020. Mr. Pino alleged that the statements of Grant Cardone and Cardone Capital were misleading. However, in April 2021, the district court dismissed the case, ruling that Cardone wasn't a seller under the Securities Act and that his statements were not actionable. Shortly after, Mr. Pino apparently filed an appeal to the district court's ruling. But then an incredible tragedy struck. On February 11, 2023, Mr. Pino sadly passed away. On February 22, 2023, the appeals court issued its decision on Mr. Pino's first appeal. The appeals court reversed the district court's decision in part, ruling that promoting securities on social media could constitute solicitation under the Securities Act. On June 8, 2023, came an incredibly courageous move. Louis Pino's daughter, Christine, became the successor in interest and replaced her late father as the lead plaintiff in the case. Christine Pino then filed a second amended complaint in June 2023. Ms. Pino added greater detail and further allegations to the claim, and so the legal battle continued. In June 2025, the appeals court issued its decision on the amended complaint. The appeals court reversed the other part of the decision of the district court by ruling that fraud does not need to be proved. Mere misleading statements were sufficient to continue the claim. The court also found that the plaintiffs successfully alleged that Grant Cardone's statements could subjectively and objectively be false. Remember that SEC letter we discussed earlier? Well, the plaintiffs pointed to that SEC letter as evidence that Grant Cardone may have known the statements to be false when he made them. Cardone Capital argued investors ought to have seen that letter online, but the court ruled that most everyday investors never check EDGAR. So the fact that the SEC letter was public does not excuse marketing activity that was potentially misleading. So the question is, what happens now? Well, the appeals court decision in February 2023 and June 2025 have almost entirely reversed the court's dismissals of the case. And the matter has been sent back to the district court to proceed. My view, although the total investment of investors was almost $80 million, it is unclear how many investors have actually joined the class action. And like I said earlier, it's open for approximately 3,500 investors to join. So a quick and easy settlement may not be likely or possible. Maybe some investors actually want to stick with Team Cardone. Also, there is the question of damages. I mean, is there any evidence that anyone lost any money? I understand some funds may be underperforming, but that's just at the moment. Maybe if it continues to underperform, perhaps investors may be entitled to a shortfall of the promised 15%. So what if they average a return of over 15% by the time the matter was heard? See, the SEC may still penalise Cardone Capital even if there is no damage. However, if investors suffered a loss, they may seek rescission, which would allow the plaintiffs to receive a full refund on their investment, and maybe some interest and legal costs as well. But hey, this is the American legal system, and I'm getting into unfamiliar territory here, so if there's any US lawyers watching, help me out and pop your thoughts in the comments below. As far as Grant Cardone's statements on social media, in my opinion, they're incredibly foolish. I can't see any excuse for a CEO of a company to make such representations. But let's face it, Grant could talk underwater with a mouthful of marbles. And you'd be forgiven for thinking he talks so much that he'd be bound to eventually say something that would land him in hot water. I think we've all got mates like Grant Cardone. They're optimistic, they don't think too much before they act or speak some of the time. The thing is, Grant Cardone could have really meant everything he said. I mean, this doesn't absolve him of liability, but I'm more concerned about his team advising him and Cardone Capital on SEC compliance. In my experience, where companies are run by these fast and loose operators, their professional advisors will usually have their back and pull them into line from time to time. Maybe that didn't happen here. But let's say someone at Cardone Capital's team was asleep at the wheel and they didn't review any of Grant's marketing content. You'd think at least someone from his team should have notified investors and the public about that SEC letter. I mean, they updated the offering documents, they had knowledge. But let's say Cardone Capital's team did advise to notify investors of the SEC letter and not make those claims on social media, and Grant went against that advice. I have serious concerns not only about Cardone Capital's liability to investors, but the penalties from the SEC, which could include heavy penalties against Grant personally. Some say this changes the investment marketing landscape. I would have thought it would have been blindingly obvious not to guarantee returns. However, the Ninth Circuit Court made this crystal clear. For anyone promoting investment opportunities online, the same rules that apply to traditional security offerings now apply to social media content. And remember, the SEC is watching. So what can we learn from Grant? Well, for a start, don't taunt the SEC in statements on social media, and don't guarantee returns. And whatever you do, don't say you can predict investment returns as if you were Nostradamus. Most importantly, get proper advice.